Good day. So we're going to tackle about the non-institutional corrections. So we are the Ca2-Caa Group 2. So non-institutional corrections tackles about will tackle about the historical perspective of the development of community-based corrections, the probation, parole, and other forms of non-institutional reformation. Introduction of community-based corrections. Not all convicted offenders have to serve their sentence behind bars. Some are allowed to stay in the community, subject to conditions imposed by the government. They are either granted probation, parole, conditional pardon, or recognizance. Non-institutional corrections refers to that method of correcting sentenced offenders without having to go to prison. So, what are the advantages of community-based corrections? So, the advantages of community-based corrections are family members need not be victim also for the imprisonment of a member because the convict can still continue to support his family, not to be far away from his children. Rehabilitation will be more effective as a convict will not be exposed to hardened criminals in prison who will only influence him to a life of crime. Then, rehabilitation can be monitored by the community. Thus, corrections can be made and be more effective, and cost of incarceration will be eliminated, which is extremely beneficial, especially to a cash-strapped government. Then, before we proceed to discussions about the parole and others, uh, first we are going to recall about the definition of terms. That is simple recall and definitions of definition and terms. So, absconding petitioner. So, it is the person who application has given due course by the court but fails to report that the probation officer of his location cannot be located. Absconding probationer. Person whose probation is granted but failed to report for supervision within the period ordered by the court of his location is unknown. Absolute pardon refers to the total extinction of the criminal liability of the individual to whom it is granted without any condition. Then amnesty. It is an act of the sovereign power granting oblivion of a general pardon for a past offense, and is rarely, if ever, exercised in favor of a single individual, and is usually exerted in behalf of certain classes of persons who are subject to trial but have not yet been convicted. Benefit of clergy. Church people are exempted from governmental punishment but are persecuted in accordance with the law of the church. Then, national carpeta refers to the institutional record of an inmate which consists of his mittimos or commitment order issued by the court after conviction, the prosecutor's information and the decisions of the trial court and the appellate court, if any, certificate of non-appeal, certificate of detention, and other pertinent documents of the case. Client refers to a parole pardonee who is placed under supervision of a probation and parole officer. Executive clemency. Under Section 19, Article 7 of the Constitution, except in the cases of impeachment or as otherwise provided therein, the President may grant reprieves, commutations, and pardons, and remit fines and forfeitures after conviction by final judgment. National prisoner. One who is sentenced to maximum term of imprisonment of more than 3 years. or to fine of more than 5,000 pesos or regardless to the length of sentence exposed by the court, to one sentence for violation of the customs law, other laws within the jurisdiction of the Bureau of Customs or enforceable by it, or to one sentence to serve 2 or more prison sentences in the aggregate exceeding to the period of 3 years. Non-institutional corrections refers to the use of variety of officially ordered programs that permit conviction or offender to remain in the community under supervision, an alternative to active imprisonment. Pardon refers to the prisoner pardonee who is released on conditional pardon. Parole, the conditional release of an offender from a penal correctional institution after he has served the minimum period of his prison sentence under the continued custody of the state and under conditions that permit his reincarceration if he violates the conditions of his release. Then parole supervisions refers to the supervision, surveillance by the probation and parole or parole pardonee. Petitioner, a convicted defendant who files a formal application for probation, position under which is defendant after conviction is released subject to a condition imposed by the court and to the supervision of the probation officer. Probationer means a person placed on probation. Then recognizance. It is a mode of securing the release of any person in custody or detention for the commission of an offense who is unable to post bail due to abject poverty. Then release document refers to the conditional pardon, absolute pardon issued by the President of the Philippines to prisoner to the discharge of parole issued by the board. Remission. The President may prevent the collection of fines or confiscation of property. Reprieve refers to the deferment of the implementation of the sentence of an interval of time. It does not annul the sentence but merely postpones or suspends its execution. Sanctuary, a city or region or church where state's agents were forbidden to enter for purposes of arresting the accused. Summary report refers to the formal report submitted by the probation and parole officer of his supervision of a parole pardonee as basis for the latter's final release and discharge. Supervision, the continuing relationship between the probationer and the probation officer. Infraction report refers to the reports submitted by the probation and parole officer and violations committed by parole pardonee of the conditions of his release and parole for conditional pardon while under supervision.
Notable personalities: the Superintendent of Penal Colony of Norfolk Island in Australia, who introduced a progressive humane system to substitute for corporal punishment. When a prisoner earned a required number of marks, he was given ticket of leave, which is equivalent of parole. The first thing that Ca2-Caa did was eliminate the flat sentence, a system that had allowed no hope of release until the full time had been served. Then he developed a mark system whereby a convict could earn freedom by hard work and good behavior. This put the burden of release the convict, as Ca2-Caa said. When a man keeps the key of his own prison, he is soon persuaded to fit into the lock. According to Captain Alexander Ca2-Caa, the father of parole and the superintendent of Penal Colony and Norfolk Island in Australian who introduced a progressive humane system of substitute for corporal punishment. When a prisoner earned a required number of marks, he was given ticket of leave, which means if sentenced person had made good works inside the imprisonment facility, it was recorded as a minus of the days he was serving in the imprisonment. The system was called mark system by Ca2-Caa. The warden of European and later of Ca2-Caa, which he felt was one of the most influential persons in the development of early prison discipline in America. He is described as having been a strict disciplinarian who believes that all convicts were cowards who could not be reformed until their spirit was broken. To this end, he devised a system of brutal punishment and regarding procedure, many of which remain as accepted practice until very recent times. Elam Lenz, he is the warden of Eoborn and later of Ca2-Caa was the most influential person in the development of early prison discipline in America. Elam Lenz, who described as having been a strict disciplinarian who believes that all convicts were cowards who could not be reformed until their spirit was broken. He is the author of Brutal Punishment and Regarding Procedure. American Prison Reform founded the New England Women's Auxiliary Association of the United States Sanitary Commission, worked with homeless and bargained women after the Civil War through the Deham Asylum of discharged female prisoners and served as superintendent of Massachusetts Reformatory Prison for Women and Framingham. Ellen Tennessee Johnson, she is an American prison reform, founded a New England Women's Auxiliary Association of many other reformatory prison for women. She was a founder and superintendent in some reformatory for women. He was famous of establishment of agricultural colony for delinquent boys in France in 1839. The boys were housed in cottage with house father as in charge. The system was based on reduction rather than force. When discharged, the boys were placed under the supervision of the patron. Frederic Auguste Demetz, he was a famous an establishment colony for boys in France. His system was based on reduction rather than force. The first director of Federal Bureau of Investigation is Edgar Hoover. Father of penitentiary science is Jean Jacques Villian. Boston bootmaker, who is called father of provision in the United States because of his pioneering efforts to campaign for more lenient sentence for convicted criminals based on their backgrounds. In 1841, Augustus approached the Boston, Massachusetts police court and persuaded them to let a common drunkard believe in his care instead of going to prison. The conditions were that a fine needed to be paid and the offender must return before the court in 3 weeks. After 3 weeks of being Augustus' care, in which Augustus found a job and made him sign a pledge to stop drinking, the offender and Augustus returned to astonish the court. The offender was completely sober and his appearance Timor had drastically improved. The court allowed Augustus to take more and more offenders into his custody. John Augustus Boston Bootmaker, who is called the father of provision in the United States because of his pioneering efforts to campaign for more lenient sentence for convicted criminals based on other backgrounds. He invited the convict person into his custody instead of going to prison and reformed the convicted by giving a job and making a pledge to stop the wrongdoings. His system is more of the reforming the bad attitude of the convicted. He was the fourth of final warden and Alcatraz Federal Penitentiary, which was situated at Alcatraz Island, California, US. Ang nagkuha na ni si Olin Guy Blackwell. He was the first director of Federal Bureau of Prison is si Sanford Bates. He was the first director of Federal Bureau of Prison. Sir Evelyn Ragos Brace, he was the director and the earliest best reform institution for young offenders in 1897. Chairman of Director in Prison in 1856, Crawford introduced the IRS system, later on called the Progressive State System. Sir Walter Crawford, he is the chairman of the Director of Irish Prison. In 1856, Crawford introduced the Irish system, later on called the Progressive Stage System. In 1876, the New York State Reformatory of Elmira was established with Brockway as superintendent. Brockway introduced in Elmira a new institutional program for boys from 16 to 30 years of age. Ang nagkuha na ni si Zebulon R. Brockway.
Provision. Ang provision is the subject of critical examination and evaluation. The word provision is derived from probatum, Latin for the act of proving. Provision is a trial period that must be completed before a person reviles to return benefits or freedom. Historical background of provision. The origin of provision can be traced to English criminal law of the Middle Ages. Harsh punishments were imposed on adults and children alike for offenses that were not always of serious nature. Sentences such as branding, flogging, mutilation, and execution were common. During the time of King Henry VIII, for instance, no less than 200 crimes were punishable by death, many of which were minor offenses. In the 13th century, efforts were made to mitigate harshness of penal laws through more enlightened and rehabilitative approaches in the treatment and correction of offenders. These practices in early English courts became the forerunners of provision which was later established in England and the United States. In the United States, particularly in the Boston, Massachusetts, John Augustus or a cobbler stood bail for a drunkard in 1841. In the course of his dealings with the offenders, he developed several features, some of which, as will be seen later, became standard practice of provision. These features included selectivity of screening, Sup- supervision of the activities of the offenders, use community resources, the provision of a place for the offenders, and independence submission of progress reports to the court, and the maintenance of the record filing system. The same procedures as developed by Augustus was used. However, investigations were scanty, probation period short, and plans of treatment of supervision were not much in evidence. Provision became firmly established during the second half of the 19th century when in 1878 the state of Massachusetts started the first paid provision officer for the courts of criminal jurisdiction in the city of Boston. On March 4, 1925, through the efforts of Charles Lionel Coate, the first Federal Provision Act of the United States was approved.
Historical background of provision in the Philippines. In the Philippines, provision for juvenile probation have been embodied in the Article 80 of the Revised Penal Code since its enactment in 1932. The sentence was suspended for offender under 16 years of age accused of a grave or less grave felony, who were then placed in the care of custody of public or private entities. This was amended on December 10, 1974 by Presidential Decree number 603, known as the Child and Youth Welfare Code, and by Presidential Decree numbers 1179, which set the age of minority to below 18 years of age at the time of commission of the offense. Likewise, Republic Act number 6425 or the Dangerous Drug Act of 1972 provided in the suspension of sentence and provision of a first offender under 18 years of age at the time of the commission of the offense, but not more than 21 years at the time when judgment should have been promulgated. To move the integrity adult provision in the Philippines criminal justice system began early in the 20th century when the Philippine Legislature approved Act number 4221 on August 7, 1935. This created a provision of office under the Department of Justice and provided provision for its offender 18 years of age and above who were convicted of certain crimes. Section 11, the fatal provision of the Act, provided that this Act shall apply only in those provinces in which the respective provincial board have provided for the salary of a provision officer. The court held that Prohibition Act did not, by the force of any it is provinces, fix and impose upon the provincial board any standard or guide in the exercise of their discretionary power. What was granted was a roving commission, which enabled the provincial board to exercise arbitrary discretion by Section 11 of the Act. The legislature did seemingly on its own authority extend the benefit of the Act to the province but in reality left the entire matter for the various provincial board to determine for themselves whether the provision law should apply to their provinces or not at all. The applicability and application of the Act was entirely placed in the hands of the provincial board. If a provincial board did not wish to have the Act applied in its province, all it had to do was to decline to appropriate the needed amount for the salary of a probation officer without even stating in the reason. Therefore, the plain language of Section 11 was not susceptible of any other interpretation. This was a virtual surrender of legislative power of the provincial boards.
My topic is all about parole and probation administration. The probation administration was created by virtue of Presidential Decree number 968, the Probation of Law of 1976, to administer the probation system under the Executive Order number 292, the Administrative Code of 1987, which was promulgated on November 23, 1989. The Probation Administration was renamed Parole and Probation Administration and give the added function of supervising prisoners who, after serving part of their sentence in jail, are released on parole or are granted pardon with parole condition. Ang Probation Administration create ni siya pagka 1976 nga ang nagdumala is probation system, then gipromulgate ni siya pagka November 23, 1989, then girename ni siya sa parole of probation of administration. Kibuhat ni siya para ma-supervise ang mga prisoner. Mandate the Parole and Probation Administration and mandated to conserve and or redeem the convicted offender and prisoner who are under the probation of parole system. Gi-mandate ang parole probation sa administration sa mga offender and prisoner nga under sa parole system. Vision: a model component of the Philippines correctional system that shall enhance and quality of life of these clients through multidisciplinary programs and resources, an efficient organization, and highly professional committed workforce in order to promote social justice and development. Their vision is para sa mga enhance nga disciplinary sa mga offenders and prisoners and the same time para ma-promote ang social justice development. Mission: to rehabilitate the probationer and parolees and pardonees and promote their development integral persons by utilizing innovative interventions and techniques which respect the dignity of a man and recognize his divine destiny. Ang mission is para rehabilitate ang mga probationer ug ma-develop ang ilang mga skill and techniques. Goals: the administration program set to achieve the following goals. A. Promote the formation of criminal offenders and reduce to incidents of recidivism, and B. Provide the cheaper alternative to the institutional confinement of first-time offenders who are likely to individualize community-based treatment programs. One of the goals is para ma-reformation ang mga criminal offenders and ma-reduce ang recidivism, like example, bago pa sila nakagawas gikan sa prisuhan, ang probationer nangawat na pod og balik. So mao nang ilang gigol para di na mobalik buhat sayop sa mga ilang dili maayo nga gibuhat. Functions agency throughout its network of 15 regional and 204 field parole and probation office perform the following function: to administer the parole and probation system, to exercise the supervision over parolees, pardoners, and probationers, and promote the correction and rehabilitation of criminal offenders. Fact on probation. What is probation? Probation: a person convicted of criminal offense is not sent to prison by the sentencing court. Instead, he or she is released and placed under the supervision of probation office, subject to the condition which court may impose. Probation is once of convict as a criminal offense. Ang person bisan nga sidya sa prisuhan, i-train na sila sa para sa makita nila ilang skills, tudloan na sila sa mga good way para di na mo usab sa mga ilang gibuhat nga dili maayo. It's a provision right. No, it's the more privilege for adult offenders. And however, under RA number 9344 of Juvenile Justice and Welfare Act of 206, a child is conflict with the law. Ca2-Caa is granted right to probation as an alternative to imprisonment if qualified under the provision of law. Who can apply the provision? Any first-time convicted offenders who are 18 years old and above ang makaplera ni mga 18 pataas. And who cannot be granted provision? PD number 968 and amended and further amended by RA number 10707.
Executive clemency. Executive clemency shall refer to absolute pardon, conditional pardon, with or without parole conditions, and commutation of sentence as may be gathered by the President of the Philippines upon the recommendation of the Board of Pardon and Paroles. In accordance with Section 19, Article 7 of the 1987 Philippine Constitution, the President has the plenary power to grant executive clemency, except of the following three constitutional limitations to it. In case of impeachment, In case involving of election laws, the rules regulation as provided in Section 5, Paragraph C, Article 9 of the 1987 Philippines Constitution, without favorable recommendation of the Commission of Election and in case where the conviction is on appeal or has not become final and executory. What are those extraordinary circumstances that may be present for the board to recommend to the President the grant of executive clemency? The trial court or appellate court in its decision recommended the grant of executive clemency for the inmate. Under the peculiar circumstances of the case, the penalty imposed is too harsh compared to the crime committed. Evidence which the court failed to consider before conviction which would have justified an acquittal of the accused. Inmates who are 70 years old and above whose continued imprisonment in inimical to their health as recommended by the physician of the Bureau of Corrections Hospital and certified under oath by physician designated by the Department of Health. Inmates who suffer from serious, contagious, contagious or life-threatening illness, disease with or with severe physical disabilities such as those who are totally blind, paralyzed, bedridden, etc., as recommended by the physician of the Bureau of Correction Hospital and certified under oath by physician designated by the Department of Health. Alien inmates where diplomatic considerations and amity among nations necessitate review and such other similar or analogous circumstances whenever the interest of justice will be served thereby. Eligibility for review of case for executive clemency other circumstances. That's all.
Amnesty, a special form of pardon exercised by the President of the Republic, is amnesty. Amnesty is a general pardon extended to a certain class of people who are usually political offenders. In amnesty, the concurrence of Congress is needed and the courts also take judicial notice of the act by the President. It can be granted before or after conviction by the courts. Ang amnesty mao ni siya ang konsiderasyon nga ihatag sa mga nagbuhat og krimen bahin sa national security, rebellion o political offenses. Sa pag-grant og pardon naa nay case nga na-file ini. The Philippines has issued 2 amnesty proclamations in the past. The first one was issued under Presidential Proclamation number 51 Biden President Manuel Rojas amnestying those who collaborated with the Japanese during World War II. The second was Proclamation number 76 issued by then President Elpidio Quirino extending amnesty to leaders and members of the Hukbo ng Bayan laban sa Hapon. Hukbalahap or Huk pambansang kaisahan ng mga mambubukid, which is organization of peasant fighting for agrarian reform and is part of the communist underground movement. So organisasyon ni sa mga magsasaka nga ilang gi paglaban ilang land. What is the nature of amnesty? Amnesty looks backward and abolishes and puts into oblivion. Means ang amnesty na murag nahagbong siya sa limot ba na abolish na hagbong sa limot. The offense itself, it so overlooks and obliterates the offense which he is charged. The person released by amnesty standards before the law as though had committed no offense. Distinguish amnesty from pardon. Pardon, amnesty, private act The one invoking is must prove it. Public act which court should take judicial cognizance, granted to common crime doers or common crime criminals, granted to political offenders. Looks backward, I forward, does not restore the right to hold public office unless these rights are expressly restored by the pardon. Looks backward and put in oblivion the offense itself. The person released on amnesty in the eyes of the law is new person who committed no offense, does not exempt except from civil indemnity, may obliterate civil indemnity. What is procedure in the grant of amnesty? Presidential proclamation of amnesty. Applicant of amnesty must admit his guilt. Ad hoc committee reviews the application. Application is referred to Secretary of National Defense or COMELEC as the case may be for comment. Ad hoc committee recommends to the President and pardon means mao ang paghatag og chance nga minusan ang consequences sa usa ka tawo sa iyang gibuhat nga krimen. Ang makagrant og pardon ang president sa nasod. Ang reprieve. Like pardon, reprieve is also another prerogative exercised by the President of the Philippines. Generally, it is applied to death sentences already affirmed by the Supreme Court, but it can also be invoked in other cases that have become final. Reprieve is the temporary stay of the execution of a sentence. Like pardon, the President can only exercise reprieve when the sentence has become final. Generally, reprieve is extended to death penalty prisoners. The date of execution of sentence is temporarily postponed indefinitely to enable the chief executive to thoroughly study the petition of the condemned man for commutation of the sentence or pardon. Ang reprieve mao ang temporary cancel sa punishment nga nahatol sa usa ka tawo nga nibuhat og krimen, labi na tong mga naay giatubang death penalty ug nga hatol.
Marvel Bar, I am tasked to report the commutation of sentence. Commutation of sentence shall refer to the reduction of the duration of a prison sentence. It is another prerogative of the President. It is an act of clemency by which a heavier or longer sentence is reduced to a lighter or shorter term. Commutation does not forgive the offender but merely reduces the penalty of life imprisonment or death sentence for a term of years. So commutation dili ma-forgive ang sa usa ka offender, but kanang they reduces the penalty from life imprisonment to a lesser or a shorter years. Commutation of sentence also benefits inmates sentenced to a fix of a determinate sentence, which renders him or her eligible for parole. Commutation of sentence changes the original fixed sentence to a lesser intermediate sentence, which will then enable the beneficiary to be released on parole. Commutation is also appropriate to use with convict sentenced to several counts. The sentence may be commuted to one single intermediate sentence through commutation and rendering the recipient to the avail of parole after serving the minimum sentence. So, commutation of sentence has a qualification. The criminal offender should serving his sentence and he himself was being guilty by the court or proven guilty by the court. So in order for her or him to avail the commutation of sentence. So next is parole. The release of prisoners before the expiration of his maximum sentence is what is called parole. So in year 1957, parole is defined as a method of selectively releasing an offender from an institution prior to completion of his maximum sentence, subject to conditions specific by the paroling authority. A method whereby society can be protected and the offender can be provided with a continuing treatment and supervision in the community. So, parole. Parole is more likely as commutation of sentence. Parole is a privilege given to the criminal offenders that serving their sentence that kanang they are proven guilty. So parole is a way of is the way of privilege that given by the government in order for them to become a law-abiding citizen when they are put in the society. History of parole. Rooted in 18th century English penal practice of indentured servitude. From 1775 through 1856, English offenders were sent to Australia, or known as Norfolk Islands. Captain Alexander McConaughey developed the ticket of leave or mark system. The system had 5 principles. Release should not be based on the completing of sentence for a set of period of time, but on the completion of the determined and specified quantity of labor. In brief, time sentence should be abolished and task sentences substituted. So the 5 principles of the mark system are: first, while in prison, he should earn everything he receives. All sustenance and indulgences should be added to his debt of marks. Second, when qualified by discipline to do so, he should work and associate with a small number of other prisoners, forming a group of 6 or 7. The whole group should be answerable for the conduct and labor of each member. In the final stage, a prisoner, while still obligated to earn his daily tally of marks, should be given a property interest in his own labor and be subjected to a less rigorous discipline to prepare him for a release into society. So in 1856, Sir Walter Crofton introduced the Irish system, which was later called the progressive state system. He reasoned that if penitentiaries are places where offenders think about their crimes and can decide to stop their criminal misbehavior, then there must be a mechanism to determine that this decision has in fact been made, as well as a mechanism for getting the inmate out when penitence has been done. The third, the indeterminate sentence, was believed to be the best mechanism. Crofton devised a series of stages, each bringing the convict closer to the free society.
So good day, so this is my topic, the Board of Pardons and Parole. The exercise of his constitutional power to grant, except in cases of impeachment, reprieves, commutations, and pardons after conviction by final judgment. So, mao nagsulti sa Section 19, Article 7 the 1987 Philippines Constitution. Act 4103 nahimo ang Board of Indeterminate Sentence. Sa Executive Order Number 33, na-change ang name from Board of Indeterminate Sentence to Board of Pardons. Executive Order Number 94, na-rename na pod, naghihimong Board of Pardons and Parole. Petition for parole should be addressed to whom? Ang petition for parole should be addressed sa chairman or sa executive director of the board. However, the board may motu proprio consider cases for parole, commutations of sentence, or conditional pardon of deserving prisoners whenever the interest of justice will be served thereby. Responsibilities of Board of Pardons and Parole. Look into the physical, mental, and moral records of prisoners. Kung kinsa tong eligible para sa parole or any form of executive clemency determines the proper time of release of such prisoner on parole. Assist in full rehabilitation of individuals on parole or those under conditional pardons with parole conditions by way of parole supervision, and recommends to the President of the Philippines the grant of any form of executive clemency to prisoners other than those entitled to parole. So, these are the disqualification of parole. Those convicted of an offense punished with death penalty or life imprisonment, kantong nakumbikto na o na sentence o death penalty. Those convicted of treason, conspiracy, or proposal to commit treason or espionage. Apil na po itong mga nakonbikto sa treason, sa conspiracy, or espionage. Those convicted of misprision of treason, rebellion, sedition, or kudeta. Those convicted of piracy or mutiny on the high seas of Philippine water. Yung kadto mga kuhan ko no, parang kuhan sa dagat ni. Those who are habitual delinquents, those who within a period of 10 years serious physical injury, robbery, thief, estafa, and falsification are found guilty of any said crimes a third time or oftener. Yeah. Those who escaped from confinement or evaded sentence at takas sa prisuhan. Those who, having been granted conditional pardon by the President, shall have violated any of the terms thereof. Those whose maximum term of imprisonment does not exceed 1 year, or those with definite sentence. Atong mga na priso pero wala kaabot og 1 year, mao na siya disqualified sa parole. And also those convicted of offense punished with reclusion perpetua, or those sentenced were reduced to reclusion perpetua by reason of Republic Act number 9346 enacted on June 24, amending RA number 7569 dated January 1, 2004, and those convicted for violation of the law on terrorism, plunder, and transnational crimes. Difference between parole and probation. Parole is different from probation in that the parole is administrative function of the executive branch of the government, while the probation is a judicial function. Sa parole, ang offender serves part of the sentence is sa prisuhan siya before siya ma-release, while ang probation is dili siya isod sa prisuhan, community based na siya, or in other words, ang parole is extension na siya sa institutional treatment. So ang probation is one substitute sa imprisonment. Ang parole is granted by the board, while the probation is granted by the judge. Both releases are conditional and subject to supervision of a parole or probation officer. Thank you and God bless.